Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know how across our corporate team. Hi everyone. So this month I've got two cases for you, both of which highlight some of the issues that can arise when documents are wrongly executed, which is something we see quite a lot actually. And then I thought also we'd have a quick look at potential reforms to the national security and investment regime, which has really had quite a big impact on corporate transactions since it came into force back in January 22. So, first up, let's get into these cases then. So, the first one, the High Court considered a consultancy agreement that had supposedly been executed as a deed on behalf of a company. But actually, it had been signed in the wrong place and it had been signed by two signatories who were not actually directors of the relevant company at the time of signing. So, the key question was the agreement still effective as a deed? So we need to remember here we're dealing with a deed. So what is that? Well, a deed is a particular type of written agreement which has to be signed or executed in accordance with certain prescribed formalities. So loads of agreements can be drafted as a deed, but they're actually only required in a pretty limited number of cases. So you have to have a deed if you're doing a transfer or a lease over land, or a legal mortgage or charge over land, or if you're granting a power of attorney, or if you're appointing a trustee. We also see deeds being used in order to cure a lack of consideration from one of the parties to a contract. So, for example, a guarantee will typically be executed as a deed because generally there's no consideration given to the guarantor in return for them giving the guarantee. Now, why does it matter whether a document is a deed or not? Well, one of the key differences between a simple contract and a deed is that the limitation period for bringing a claim under a contract is 6 years, but the period for bringing a claim under a deed is 12 years. So parties sometimes choose to execute an agreement as a deed, even where that's not technically required, just in order to take advantage of that longer limitation period. So, in terms of how a deed has to be executed, the legal requirements are that an individual party has to sign a deed in the presence of a witness who attests their signature. But a corporate party to a deed has three choices. So, it can execute the deed either by the signature of a single director signing in the presence of an attesting witness, or by the unwitnessed signatures of two authorised signatories. And authorised signatories here are just the company's directors and its secretary. And then the third method is by using the company's common seal, by affixing the common seal to the document. That's the technical term, but that's pretty rarely used in practice nowadays. So in this particular case, there was a dispute that arose out of the construction of a new oncology centre at Jimmy's, St James's Hospital in Leeds. The contractor brought a claim against the consultant under a consultancy agreement, and the key question for the court was whether or not that agreement took effect as a deed. If it was a deed, then the relevant limitation period for claims would be 12 years. But, as I say, if it was a contract, then the limitation period would only be 6 years and the claim would effectively be time barred. So, as I've already mentioned, there were these problems with the way in which the corporate consultant had executed the consultancy agreement. In particular, the two purported signatories were employees of the relevant company, but they weren't statutory directors. And then also, they'd signed in the wrong place. So they'd signed in the execution block for witnessing the affixing of the company seal rather than the execution block for signature by two directors. So, when it looked at all the evidence, the court said that notwithstanding the failure to comply with the strict legal requirements, the consultancy agreement did take effect as a deed. So, in relation to the fact that it had been signed in the wrong place, the court said, well, that was just an error. There was never any intention that it should have been executed by using the company's seal, which would have been, in particular, that would have been completely inconsistent with the approach taken to all the other documents that have been signed at the same time. The signatory's intention had clearly been to sign in the section below the one in which they'd actually signed, i.e., the section providing for execution by the signature of two directors. So it was just if you like, an administrative error. And then in relation to the fact that the two signatories were actually just employees and they weren't directors, here the court said that the consultant company had held those signatories out as being in the position of directors and having authority as such on behalf of the company. So because of that, the company couldn't now deny that the signatories had the authority normally associated with that position. And crucially, the company had accepted that the signatories had authority to act as they did, and the parties had proceeded with the arrangements between them on the basis of that signed agreement. So they'd assumed that it was valid, that the signatories could sign it on their behalf. And in doing that, the signatories weren't acting improperly in relation to the company, but actually they were doing exactly what the company had expected them to do. So although in this case the court did say yes, the agreement, that consultancy agreement, was effective as a deed, it did also highlight that the statutory requirements specifying the formalities necessary for a document to operate against a company as a deed should not be readily circumvented. And although the court did save the agreement, I don't think it would be a good idea for anyone to rely on it to justify execution by non-directors in other circumstances. In particular, the question of whether a non-director has been appropriately held out by the company and has acted within the scope of their authority is going to be very fact specific, and it could also be quite difficult to prove. The other thing just to mention in connection with that decision is that by reaching the conclusion that they did, what the judge did was prevent a consultancy company relying on its own invalid execution in order to avoid a claim under the agreement. Remember, if it wasn't a deed and it was just a simple contract, then the limitation period would have expired and the company would have avoided a claim being made against it. So I think possibly in other circumstances, the court might be more reluctant to validate execution of a deed by non-directors. So an interesting case, but like I say, I would always try and execute your documents properly in the first place, rather than having to rely on the benevolence of the court in upholding your valid execution. Okay, moving on then. The second case involving more problems with execution related to an assignment of contracts which had been signed by an attorney. So here, the High Court held that the assignment was not a valid legal assignment as it hadn't been signed by the assignor himself, but actually, like I say, by his duly appointed attorney. So again, it's this case a bit of a useful reminder of the strict requirements for valid legal assignments. So we've looked at deeds. Let's look at assignments now. So an assignment is the transfer of an existing right or interest, such as the benefit of a contract, from one person to another. After the assignment, the assignee, the person to whom that right or interest has been transferred, they're basically entitled to enjoy the benefit of the contract and to enforce their rights against the other contracting party. So assignments can take different forms. They can be legal assignments, also known as a statutory assignment. That's a kind of more formal one, if you like. Or they could be an equitable assignment, slightly more casual, maybe. Parties usually try to create a legal assignment rather than an equitable one because legal assignments allow the assignee to enforce the assigned rights in their own name. But in contrast, if you've only got an equitable assignment, then the equitable assignee has to join the assignor, so the person that transferred them the right, in any action against the other party to the agreement. So it's just a little more difficult to enforce. So there are very strict legal requirements for a legal assignment, and those include the fact that the assignment has to be in writing and it has to be signed, and I'm quoting here, under the hand of the assignor. Equitable assignments, so the other sort of slightly more casual ones, they often come into being because an assignment has been created, but it doesn't quite meet the requirements, the full strict legal requirements for a legal assignment. So in this case, the court was asked to determine whether the rights under two loan agreements and a guarantee had in fact been validly assigned. So the defendants in the case argued that the assignment was ineffective because it had been signed on behalf of the assignor by an attorney acting under a power of attorney. This means that they said that the assignment had not been signed under the hand of the assignor as required by law. So when the court looked at it, it said no, there has not been a valid legal assignment. So to be effective, the assignment had to be in writing. That's fine, it was in writing, and it had to be under the hand of the assignor. And the court said an assignment signed by the assignor's attorney didn't satisfy that particular requirement. It rejected the argument that execution of the assignment by the attorney was sufficient for it to count as being made under the hand of the assignor himself. And when making that decision, the judge basically relied on previous case law that suggested that an ordinary agent could not sign a legal assignment on behalf of an assignor. Now, in fact, the court sort of went on to save the claims because it said, well, although the court, although it's not a valid legal assignment, it is going to take effect as an equitable assignment. So it was a bit of a controversial decision, this one. Um, the cases that the judge relied on involved ordinary agents, so not duly appointed attorneys, which is a much more formal position. It just involved those ordinary agents signing on behalf of someone else. Um, and it's a bit surprising, I think, that the judge included attorneys in that same category as ordinary agents, particularly because the law already recognises that an attorney's signature is legally equivalent to the signature of the donor of the power, the principal. So there doesn't really seem to be any sort of obvious policy reason to prevent a legal assignment by an individual from being signed by an attorney. Now, on the face of it, um, I think this decision is only going to affect legal assignments by individuals, and it shouldn't apply to body corporates because with a company, the relevant signatory, whether that's a director or an attorney, is going to necessarily be already acting on behalf of the corporate entity, which isn't a separate person. It can't act on its own. It's not a living, breathing person. It's got to act through an agent in the first place. So the only other thing that I would just mention about that decision, it's a decision by what's known as a chancery master, so a kind of a junior judge. So it might not carry quite the same weight as a decision by a full High Court judge. I think probably, despite the sort of slight controversy around it, it's probably sensible to ensure that any legal assignment by an individual is actually signed by the assignor themselves, not by their attorney or any other agent. But I think until there's any other further judicial clarification, companies can continue to execute those legal assignments by the signature of a director or indeed an attorney. Okay, so finally, I thought I would just mention that the government has launched a review on the effectiveness of the regime for intervening in transactions on the grounds of national security. So, according to the government, the relevant legislation, the National Security and Investment Act, is functioning well, but it wants to ensure that it takes a proportionate and targeted approach, balancing the burdens it places on companies and investors with the risks to national security. So, as a quick reminder, the NSI Act requires advance notice to be given of certain transactions involving targets operating in 17 specified sectors, and a qualifying transaction which completes without clearance from the government will be void. Now, actually, since this act came into force at the start of 2022, the overall number of notifications has been a bit lower than was predicted. There were 866 in the year to 31st of March 2023 when the government published a review. Um, but although the overall number of notifications is lower, the number of interventions by final orders, so where the government has stepped in and in some way prevented or modified a transaction on the grounds of national security, that's actually been slightly higher than predicted. Um, but one of the key stats is that 93% of notified transactions are being cleared at the first hurdle without needing any detailed assessment by the government. So there are concerns there that perhaps the regime is catching matters which actually pose no real risk to national security. And that, I suspect, is something that anybody that's worked with transactions caught by the regime would probably agree with. So we've got what's called a call for evidence here, issued by the government, which is inviting stakeholders to share their views on the regime under the Act, particularly focusing on its impact on businesses and investors, whether the scope and the requirements of the regime are proportionate and effective, and how well stakeholders actually understand the system. So, two of the key areas of focus relate to the sector definitions and then whether actually we need some targeted exemptions from the mandatory notification requirements. Um, Spoiler, I think probably we do. So, in relation to the sector definitions, um, the government's interested here in whether there are activities that are within the 17 specified sectors that are, in fact, very unlikely to create national security risks. Or where compliance with the mandatory notification requirements really places substantial burdens on businesses and investors. So the government's considering things like clarifying the scope of various sectors, refining the scope of others, so perhaps reducing their range. Then they are looking at expanding a couple of sectors, so in particular in relation to communications and data infrastructure. So reducing certain thresholds, adding certain entities. And then another area is clarifying the treatment of academia. So some activities, for example, university spin outs seeking additional funding, can be caught by the NSI Act, um, and the government's thinking about whether or not that is correct. And then, as I say, they're thinking about some possible further targeted exemptions to reduce the likelihood of capturing transactions which really pose no risk to national security. So, one of the ones that they're thinking about, it relates to internal reorganizations, particularly those where the level of control held by a person over the targeted entity doesn't actually change or changes very little. So, one of the problems with the regime at the moment, if you have a subsidiary company that is caught is operating within one of the 17 sectors, you carry out a group reorganization which moves that subsidiary to elsewhere within your group, but there's no change in the ultimate beneficial owner, the ultimate holding company of the overall group. That is still a transaction which is caught by this NSI regime and would require a mandatory notification. And if you don't make that notification and get clearance, then, as I say, that transaction would actually be void. So I think it would be very welcome if that kind of an exemption was introduced. Another exemption that they're looking at, it relates to the appointment of a liquidator or an official receiver or special administrator. those appointments generally don't present any national security risks, and actually any onward sale of a sensitive entity by them would be a separate trigger event anyway. So you sort of catch it at the second stage when they're selling, not when the liquidator or receiver is appointed. So generally, I think that review of the national security regime is going to be pretty welcomed, um, particularly by advisors and investors, buyers who've seen the practical impact on transactions where, frankly, it's been clear that the target's activities clearly pose no risk to national security. And the problem is that the very draconian nature of the regime, with any unnotified in scope transaction being void, even where there are clearly no national security concerns, that has all forced parties to take a pretty cautionary approach, I think, adding unnecessary costs and timescales to transactions. So I think we will all be looking forward to the results of that review. So that's it for this month. Hope that was interesting, and I'll speak to you next month. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.